Well, an increasing number of complaints of workplace bullying, particularly alleging inappropriate conduct from senior executives, have been brought to the attention of boards. Let's get some further detail. Joydeep Hor joins us from employment law firm People and Culture Strategies. Joydeep, good to catch up with you again. So are these complaints of harassment and bullying on the rise?
Absolutely, they are. They certainly have been for a number of years now. It seems that, ironically, in spite of more cases being brought, which should lead to a heightened level of awareness of what might be problematic behaviour, we are seeing an increase in complaints year on year. And what I think is particularly interesting is that probably for the first time more so in the last 12 to 18 to 24 months, the volume of complaints alleging inappropriate behaviour, for example, by a CEO or a CFO or someone else in an exco or very senior leadership team, being escalated straight to a board for attention. Now, sometimes there is perhaps no other choice for someone who is aggrieved or who is a complainant but to do that. But in many instances, that's being done for let me call it heightened dramatic effect, and to get the curiosity or interest or attention of particular board members around this particular issue, tapping into the fact that a lot of those individuals are going to be perhaps personally concerned if things aren't done properly or in a particular way.
How are these companies handling it, particularly if there are allegations made against those at the top, the managing director or the chief executive?
Well, it's very challenging because when you're dealing with individuals at such a senior level, every decision that you make, which you would ordinarily be advised to make by someone like myself, which is you can't do anything more with that complaint at that point in time other than conduct an investigation or have an investigation conducted. That investigation needs to be independent, should be done by someone impartially, etc. And often one of the key considerations is, should the person against whom the complaint is made, the alleged perpetrator, be allowed to continue work during that particular time, or should they perhaps be stood down? Now, when you're talking about someone at a very senior level, you're going to stand down a CEO or a CFO from their role, from their duties for any period of time. That's going to cause a lot of perhaps operational and functional inconvenience for an organisation. And at the very least, it's going to give rise to lots of speculation and questioning as to, well, what happened to that person? Why all of a sudden are they not here for a particular period of time? And what always happens with investigations is that these things almost tend to take on a life of their own, and what could perhaps be something that is seen as achievable by way of an investigation being wrapped up in a week often takes weeks and sometimes even months. So really the reputation of that individual, particularly if they've been stood down for such a long period of time, is significantly tarnished throughout that particular process, even if the investigation finds that there was no wrongdoing on their part.
So Joydeep, how do you actually define bullying in the workplace? It looks to be a fairly grey area there as to whether perhaps particularly executives overstep in terms of perhaps applying pressure to those underneath them.
That's right. Now, there is a legal definition of bullying that's set out in the Fair Work Act, which says that it's defined as repeated unreasonable conduct that causes a risk to another individual's health, safety, or welfare at work. Now, that is a not massively complicated legal definition, but the reality of the complaints and the genesis for complaints being brought invariably involves an individual who has been the subject of what is broadly defined as performance management. In other words, as you say, a more senior person, a manager, whether it's a CEO or someone else, has said to that person, you need to be doing your work differently or better. And what is often the subject of the complaint is the way in which those communications have happened, or the time at which those communications have happened, or the context in which that feedback was supposedly given. So these are the bullying complaints that we see day in, day out. Now, what that means is, in the context of conducting an investigation, the person against whom the complaint is made will probably not deny necessarily engaging in that conduct. In other words, they won't say, no, I've never had any conversation with that individual about their performance. But what they will say, and are likely to say, is that they gave that feedback because it was necessary and because the person was not performing or was not doing their job in the manner that the CEO or whoever expected them to do it. So you're going to get factual alignment, but then it's a question of, well, does that meet that legal definition of bullying? Was that conduct unreasonable? Was that conduct such as to cause a risk to someone's health, safety, or welfare? In the ordinary course of a manager giving feedback around performance, that should never be the case. But this is the grey that you allude to when you talk about the definition of bullying.
Does a board need to have a framework in place to deal with the potential allegations of bullying?
It should, absolutely. And grievance handling policies, complaints mechanisms within organisations should explicitly countenance the possibility that a person or the people that are referenced in that policy as the people who employees should ordinarily go to if they feel that they've been bullied or harassed may themselves be the subject of the complaint. So the mechanisms need to be there around what should happen if, for example, it's the head of human resources or people and culture or the CEO that is the alleged perpetrator. Now, whether that involves a direct mechanism to the board or a direct line of access to the board, or whether an organisation chooses to structure it differently, as many of my clients do, where they'll have someone independent outside the organisation being the recipient of those complaints and grievances, these are things that need to be thought through. It's very important, though, that when these complaints are made, that there is a level of calmness and composure, and that no greater weight is given to a complaint than needs to be. At that point in time, it is only a complaint. It's only allegations. And even though it might seem salacious and concerning, it is important that it is dealt with clinically and in a composed manner, and recognising that it's not truth at that particular point in time. This is where I see a lot of boards getting very nervous and often making a lot of poor judgments in those early stages.
And how transparent does a board and more broadly a firm need to be if there are these allegations made? At what point do they actually air this to the broader firm? Or perhaps if they're listed, they need to bring it to the attention of shareholders?
Well, that's right. But typically that trigger should only happen at such point in time where the board has been satisfied that conduct has actually occurred. So certainly if it is nothing more than a complaint that has yet to be the subject of any kind of inquiry or investigation, then the board needs to be very careful around not exposing itself or individuals to potential claims of defamation or other kinds of unfair treatment towards the alleged perpetrator of the conduct. So they're all matters that need to be the subject of careful and diligent advice being taken and being provided. But you certainly don't want to be too quick to be disseminating information, even if it is presented in what might seem to be a neutral way. That the connotations, even of just the use of the word bullying, can often be very, very damaging for an organisation, the individual's share price and other things.